Among other things. Just days ago, the House of Assembly passed the first stage of the Sexual Offences Amendment Bill, a pivotal piece of legislation aimed at reinforcing protections for minors and addressing the growing concern over predatory behaviors, including the newly defined offence of grooming. Good evening and welcome to the People's Business. I'm your host, Teshia HInds. Good to have you in company. Joining us tonight to discuss these critical amendments, our Minister of Home Affairs, Wilfred. Good to have you with us, sir. Good to be here. And also here with us is Fabian Sargeant, who is president of the Men Education Network Support Organization. Welcome.
Good evening. It's a pleasure to be here. It's Men Empowerment.
Men Empowerment
Yes.
Network, acronym MENS. So we certainly will be delving further into what they advocate for and why they feel the need to be a part of Barbadian society in that manner. Together we'll explore the implications of this legislation, the ongoing challenges of safeguarding our youth, and the responsibilities that fall on all members of society in combating sexual offences, particularly against minors. So stay tuned as we break down these key points. That's all next. So stay with us.
Come on, you family, make some noise. Are you ready?
Q in the Community is on every Thursday in a community near you.
Q in the Community is well and alive.
Come on down and, have a line with all of me. The more mature folk come to dance, to sing.
Keep the bones smooth.
Q in the Community is your place to meet friends, to socialize, and just to be you.
Yes, come on down and take in the karaoke.
Whether you're coming from north, south, east, or west, we have a bus for you.
Q in the Community.
Stay tuned to Q100.7 FM to find out where we will be next, and follow us on Facebook.
There is a saying, you can find a Bajan anywhere. Are you a Bajan living abroad? Or do you know of one who has migrated to another country? Well, we at Morning Barbados will
Welcome back. Of course, we're encouraging you to be a part of the discussion as well. We'll encourage you to come in with your calls on 228-5562 and 228-5563 as we get started into the conversation. I want to start, now the recent amendments to the Sexual Offences Act have been described as necessary for restoring protection for minors in particular. Minister, can you elaborate on the specific measures that are being introduced that are aimed at safeguarding our children?
Okay. In the decision of the court when Justice Weeks struck down Section 12, Section 12 was the section that deals with serious indecency. And she did it because she said it was too vague. And, most people actually agree that the section left itself open to a lot of interpretation. Now, that was the section that was most used in protecting young men. If somebody was molesting a child, a boy, or exposing themselves and having the boy fondle them or fondling the boy, it came under serious indecency. So when that was actually struck out, then it was left to a simple sexual assault charge to try to cover that block. While the serious indecency, I think, carried about 15 years. Just a sexual assault carried about 5 years. So the penalty for the sexual assault was significantly less than what the penalty for what was removed. And we didn't want to leave that gap, allowing predators to be able to get off too lately where children were concerned. So the decision was taken that we had to address that deficit. As we looked at the legislation, there was a lot more that needed to be done to bring it up to date. It made no sense to just address that one part. We also have to deal with the reality of something called grooming. We know what that is. All who watch the networks and they watch those Law and Order movies, we know what grooming is where somebody cultivates a relationship with the child for the purpose of taking advantage of the child. That was not actually present. We dealt with the offenses when they happened. If somebody did something to the child, that's when the law kicked in. But it didn't kick in for those who set up the children through apparently innocent interactions aimed at a future illegal endeavor. So we just took the opportunity to clean up the entire of the Sexual Offences Act, address things that were missing, address things that needed to be done to bring it up to date. For example, we looked at the child pornography, having images of children. That wasn't properly addressed in the existing legislation. And then we took it further. I mean, a lot of back and forth went into the drafting of this. So initially the idea was to draft it so somebody who was selling images of a child or offering images for sale would be guilty of an offense. Was selling images of a child or offering images for sale would be guilty of an offense. But we said the aim now is to completely protect our children. There's no wiggle room, there's no room for error. So that even went as far as if you have an image of a child, an inappropriate image of a child on your computer, on your phone, you don't have to send it to anybody. You don't have to trade off it. The sheer fact that you have it is a criminal offense. So we've gone very, very wide to put as many protections in, especially in relation to children.
And regardless of intent, I think it's important for us to reinforce that rape also features heavily in the amendments, the matter of rape.
Yes, the matter of rape does feature significantly. The legislation was adjusted, or the new version of legislation allows, for example, a female spouse to rape a male spouse. That wasn't there before. So although the legislation defined a spouse as being a husband or wife, as the case may be, they only provided for a male to rape the female. But the definition of rape has changed. People historically think of rape as a man forcefully penetrating a woman in a sex act. We've gone so far past that. Rape includes the introduction of any body part into the mouth or anus or vagina of another person. So when you start to talk about body parts, right, and it also goes to an object as well, an object not being a part of the body into the anus of somebody. When you start to get to that, you see how a woman can actually now rape a man. So it balances out. Normally these laws, we see the women as the victim historically, but you're realizing now that the landscape has changed and we have to cover everybody. We're not just looking to cover women, not just looking to cover children, we're looking to cover anybody who is a victim of a sexual predator or an unwanted sexual experience.
Now, this is quite significant. Here's where we want to bring you into the conversation, Fabian. Not just the stress as we start on this female to male spousal rape that can now be possible, but other issues, child pornography, the serious indecency that is dealt with, all of these things that have been covered within the amendments. What are your general thoughts on these specific areas and how they relate to men and boys in particular?
Hey, I really want to thank the minister and commend them for actually the attempt to strengthen the Sexual Offences Act. For many years, men have been seen only as perpetrators, and people have not, I think society generally has seldom seen men as victims of violence. And boys, I know of many men who suffer from childhood traumas, sexual traumas that they would have experienced when they were young. These sexual traumas by women, by older women, and these things are not taken seriously because our culture is that you laugh at these things, you know. Men are supposed to do a particular thing and boys are supposed to be a particular way, not understanding the challenges that we face, the psychological, the emotional damage that men and boys face. So I really think that it is a step in the right direction. As a progressive society, these are the type of progressive approaches to laws that we would really like to see. And what pleases our hearts is the fact that there's an approach to really strengthen that against minors, because as a men's organization, we are fathers, you know, we believe in family, that's what we're about, and anything that speaks to the protection of children is always at the forefront of what we do. What I'll also add is the approach to include persons with disabilities. So, I mean, the wideness and the fact that you include these vulnerable populations and you try to really impact everybody or get everybody within covered in terms of protections within the act, I think is very commendable.
Now, Minister, the introduction of the grooming offence is a very significant step in the legislation. Can you explain for us how the law defines grooming and what type of evidence we're looking at in terms of being able to bring that to court, or what will be required to prosecute such cases effectively?
So, grooming is where you, if I skip all the entirely legal language, grooming is where you approach or interact with a child with the intention of it ending with a sexual experience. And you can be found guilty of grooming pretty much with your first act. Now, the thought process was, okay, you know, grooming should be a pattern. But exactly when you establish that pattern, is it the first act, is it the second act, is it the third act? But the further you push it down the road is the more you expose children. Because the person may attempt to groom, and if they actually do meet up with the child, right, then something may happen to the child's detriment. So it's the thought. So if we strip away completely legal, once you are encouraging or trying to cultivate a relationship with the child for the purpose of encouraging that child or getting that child into a sexual act, right, then you are doing something wrong. So you can't dance to the line and just not cross it and use the technicality that, well, nothing happened. If it is reasonable to assume, based on what you have done, that you were trying to get the child comfortable for the purpose of furthering your relationship with the child, then that would actually be grooming.
Is there provision for bringing people into a charge who might be complicit, or where there might be knowledge within the home or family where it is not pursued from that perspective?
Actually, a lot of that is more covered under the child protection legislation than this. This one deals pretty much basically with the perpetrator and the victim. There is one section in here that deals with if you allow a child to enter your premises for the purpose of somebody taking advantage of them, effectively, then you can be found guilty. But for the rest of it, the bulk of it deals strictly with the perpetrator and their gradual relationship with the child, or an immediate act that is illegal.
Now, for you, Fabian, given the sensitive nature of sexual offences, how do you think we can encourage open dialogue, not only among men but across society on these issues, without stigmatizing victims or perpetrating harmful stereotypes? Because we know that often comes with these discussions where a lot of people tend to point fingers.
Yeah. Education. We have to really start by giving information, getting people aware of the act, getting people aware of their rights, getting people understand, you know, the various behaviors associated with illegal activity. So, I mean, and it must be segmented, because where you have an act that speaks to adults and also children. I mean, recently I was in a session and I was asked, do you think children know their rights or children understand? And there was some people say yes, but I do believe that we have a lot of children, if not most of them, across this island who have no clue about what we're talking about when it comes to laws that really impact them. Adults do not know, and we have to really look at it in a real serious way at the community level, within homes, and get people understand the language sometimes even associated with these bills, you know. And once you get that information and people become a lot more aware of what's going on, it then starts to attack the quote-unquote stereotypes and their thinking and their perceptions, and we start to see some changes in what you consider the cultural dynamics of the behaviors.
All right, very interesting, and you raise a great topic in terms of ensuring that children are well informed as well. So, you know, what does this mean for our community, Minister, in terms of getting children to recognize or report such predatory behaviors?
We have to do education. A lot of people are uncertain as to exactly what the act speaks to. So if the adults are uncertain, and don't fully understand where the line is, then it's probably even more difficult for a child. But we need to talk to our children. You need to tell a child what you do. If somebody does this to you, it is wrong. I was talking to some parents the other day, and a child came and he went to give a child a bounce. And that child looked at her mommy first, and the mother nodded. So the child gave me a bounce, right? And the mother said, sorry, Missy. I said, no, that is entirely right. Because anybody can be looking to do your child harm. So we need to talk to the children and let them know certain things are not right. Be careful who you talk to. Be careful who you accept sweeties from, right? Be careful if somebody wants to take you away from where you're comfortable, right? Know your comfort level. Don't be afraid to speak out. But equally, we must make it so that our children feel comfortable coming to us and speaking to us and not being afraid that they might be punished for something that is not ultimately their fault.
All right. You wanted to add, Fabian?
I really want to also add to that, because we have a cultural situation where Bajans are private people, and things happen within the household, things happen within communities, and nobody talks about it. And if we are really if you're expecting parents to really reach out and speak to their children, we've got to find some way to provide support for parents, because we've got a lot of parents who are suffering from these same childhood traumas, who were we say interfered, but who were abused sexually as children, and who are still dealing with it. And to even have that, to start that conversation, is painful, because it brings back memories, and sometimes that also contributes to how someone parents. Sometimes they're overprotected and how they treat that child. And sometimes they have good intentions, but those good intentions go down a negative road where children start to respond differently to how a parent may be hard on them, as you would say, major parlance, So I think support is going to be also very critical if we expect parents to really open up and deal with what they have going on inside of them, and to be able to communicate better to their children.
All right, wonderful. If we're going to get through all of this, we're going to have to move quickly. So now that we've looked quickly at grooming, it's crucial for us to consider the broader implications of the bill. That's coming up next. Stay with us. Welcome back to the People's Business. We're going to go straight to the phone line because we want you to be a part of this conversation as well. I understand we have a caller on the line already. Good evening. Welcome.
Yeah, hi, good evening, teacher. Yes, hi, good evening, teacher. How are you doing? All is well?
All is well. Good to have you here. Go right ahead.
Yes, glad to hear that. Fantastic, wonderful. Yes, good evening, Mr. Minister. Good evening, Mr. Sargeant.
Good evening.
Yes, good evening. Thank you very much. I have a couple of questions, please. The first question has to do with the aspect of the mindset of where it is easier for you to have a mood of this particular behavior, and these particular behaviors being more catered to or easily being able to be allowed, because you will know that in effect, you will know that at crop over, you will know that at Christmas, and you will know that at Valentine's Day, these things are more able to be put online as well, because the behaviors are more easily able to actually happen. So what I'm saying is that my question is, how can we at those times, because of the mindset is easily able to be catered for, how can we prevent it? I know the bill is great, fantastic. I thank you so much for it. but how can we have a more practical sense of being able to help our boys and our children to be able to be so? And my second question, very quickly, how can we be able to have an issue where you have a area where you're going actually to have these children in a mindset where they're not by the age of 16 or 18 not being able to have their legislation, the age of 16 being the age of consent, being changed the age of 18, because I know that there was a child protection bill as well. And the area that these bills are being able to be put on is so great, because this government is doing so much for our children and for our disabled and this society, because the way that the bills are put, there's no more patchwork legislation. It is very good at what is being done, because it's a complete thing to really protect everybody, to keep everybody safe and to help everybody, and I commend the government for that.
All right, I want to thank you. He deals with two completely different things. I don't know if you got what I got, but initially he was talking about a mood, as in maybe, you know, a lot of people talk about crop over and different events, maybe sharing a little too much of a sexualized type society. I think that was one thing. And I think is important for us to kind of draw the line on that and say that that doesn't necessarily equate to people abusing children. That's the first thing.
Kind of. So there's also inducing children or encouraging children to perform sexual acts, or it then spins on what is actually a sexual act. So what that would catch is someone, for example, you've seen those videos in Trinidad where women are gyrating and have little boys behind them. This legislation would catch that. So, but for the caller, just please understand, right, that no matter what mood is created and what time of the year it is, anything between consenting adults is between consenting adults. So whether you don't approve of it on the street or in front of you, once they're consenting with each other, then they're not really breaking the law. If it goes towards lewdness, because in here there's also a provision for creating an opportunity for a child to watch a sexual act. So yes, it might be caught there, but if people are just gyrating and doing what they do at crop over, you may not like it, but it's not inherently illegal. Now, let me flip to the second thing he asked about the age of consent. The age of consent has not been raised to 18. There were a number of, so the age of criminal responsibility in Barbados is 12 years old. Sorry, it's now, I think it's 14 years old now. It's not being raised to 14. We had an issue before where if someone has sex with a child that was between 14 and 16, then, and you honestly believed that the child was over 16, it was not as clear cut. We've stripped away, we've taken all of the different ages, and they were confusing people, right? A child, for the purpose of our legislation, is 16 years old. The age of consent is 16 years old. At 16 years old, you can have sex, you can consent to sex, to sexual act. I just want to make that very, very clear.
Fabian, you wanted to add?
I just have to address that as well. Minister, I would like to find out, like, and it's been causing a lot of confusion, the fact that the age of 16, you can consent to sex, but that child cannot access health care or anything until 18 years old with a parent, you know, and that 2-year lull in between there creates a lot of challenges because they're sexually active. The law says, well, I can have sex. There's STIs out there, there's pregnancy and all these things, and these young people cannot access health care. So that 2-year bracket in there, do you then shift it then, if you're saying they can have sex at 16, then you should be able to access health care at 16 because sex comes with consequences and a number of different issues that, you know, these young people like to address. So it then speaks to the health and their perspective in terms of how do they access health care before, while being sexually active.
Let me clear up one other thing quickly. Is the 14 to 16 bracket also cause confusion? Because if you had sex with somebody who was 14, 15, and the person was consenting, the charge was not rape. It was sex with a minor. Right? So if the child, although they couldn't necessarily consent, the law accepted it was not forced. So the charge was a lesser charge than rape. Rape carries life imprisonment. Now we have said the age of consent is 16, a child is under 16, and a minor under 16 cannot give consent. So even now, with this change in legislation, it protects children from making bad decisions, even willingly. If the victim, if the child is under 16 years old, it does not matter whether they were a willing participant. It is no rape. So people used to say before statutory rape, and they meant sex with anybody under 16. That wasn't actually true for Barbados because the charge 14 to 16 was sex with a minor. But now we actually do have effectively statutory rape. It does not matter whether the child is consenting, willing, instigated it, set it up. If you have sex with a child under 16 years of age, then that is rape.
I guess that says the child cannot be a willing participant if it is indeed rape. Let's head back to the telephone line. We have another caller. Good evening. Welcome to the People's Business.
Good night, teacher.
Good night. Welcome.
To you on the panel. It's good seeing you.
Same here. Go right ahead, sir.
My question here is that I believe that there will be probably a higher percentage that men raping the wives than wives raping the husbands.
That's the comment. What's the question, sir?
Right, I say I believe that. So I want the partner, I want them to address that they will get a more higher percentage than wives complaining about the husband raping them than the husband complaining that the wife raped them.
I would say this. I'm actually not concerned about the percentage. If the percentage is 1, right? If the percentage is 1, we have to make the law to cover that one man who is the victim. So the legislation is trying to not identify a victim. It's trying to protect all victims. So it doesn't matter whether 10 women make the complaint as against one man. Where that one man has a legitimate complaint, he should be able to make a report and have that acted on. And I agree with you with something you said. We, as a society, I've seen men in domestic violence matters talking that the wife forced them or beat them or whatnot. And people laugh. So our society has been one that we've had the woman, we accept the woman as the victim and we rush to protect her. But we laugh at the man who's in need of protection. This legislation strips it all away. A lot of it is gender neutral. So what applies to one applies to the next, and that is as fair as it could be.
And I think that was made clear with that last call because we heard the snicker at the end as well. In terms of dealing with it. But I know this is something you deal with even in matters of domestic abuse, as the minister mentioned, in terms of men not necessarily wanting to come forward as often as we would see women coming forward. Yeah,
there's a perception that they will not be received well. That perception, even if in the police situation, having to go to the police station, have to tell another man that, well, look, this is what happened to me. Sometimes even relatives, people in their close space who don't take them serious. And there are men who've been living with abuse for many, many years, quietly, who has been impacted emotionally. And we turn a blind eye to it because as men, you're supposed to be strong, You tell a man, tell somebody that, he was hit by a woman, they laugh, man, no, man, you should do this and you should do that. And I'm telling you that we do have a lot of situations out there where men are abused, and the fact that the legislation now, I guess, support men as victims even more is great. Again, we still have to look at the cultural dynamic and breaking certain behaviors. And changing behaviors is not easy. So that is where the continuous support in terms of what we offer within the organization, our counseling, our men's groups, and our education, that is what is going to, I guess, help mitigate a lot of the issues that you see could happen.
All right, it's time for another break here on the People's Business. But when we come back, during the recent debates, we had some matters raised that we are going to be raising here ourselves tonight. Stay with us. Welcome back to the People's Business. Good to have you in company this evening. I understand we have the first female caller of the evening on the phone line. Good evening to you. Welcome to the People's Business.
Good evening to you as well. My question is this. Can a person making, a male, making a pass towards a minor, of course the minor is not 16 as yet, can that person be charged?
Yes, that person can be charged. If the person makes a sexual advance towards a minor, that person can be charged now under this legislation. That's a simple answer.
Okay, thank you.
Okay.
All right, thank you so much. Now, we know that during her contribution to the amendments to the Sexual Offences Bill, Member of Parliament for St. Philip North, Dr. Sonia Brown, raised concern about the absence of corroboration from the proposed legislation. She highlighted the issue, noting that you have to protect both the accused and the accuser.
Corroboration can support both the victim or the alleged victim and the alleged accuser. And it was really unclear, forgive my ignorance, so I would like some clarification on that, because oftentimes every case of alleged rape is not always rape. I have had personal friends that picked up a lady on the way and person asked for money. And if you don't give me money, I will report you to police for rape. Before you know it, the accuser is in court, name all over the newspaper, because there's no protection in my mind for the alleged accuser. Name all over the newspaper, all over the news, and if that person happens to be innocent or guilty, when the case is over, you're guilty by any means. Doesn't matter. You have that stand.
All right, Minister Abrams, the matter of corroboration, it has come up a few times now. So let's go through that, maybe with a fine-tooth comb as much as we can within this hour.
Okay. So, rape, when we are in law school, they always say rape is one of the easiest offenses to allege. It should be one of the most difficult to prove. So, only 2 people are usually involved in a sexual situation. It is unlikely that you have other witnesses to it. So you look for corroborating evidence. That's evidence which supports the charge. So DNA evidence, other evidence that points to the fact that something happened and suggests what it is. Now, this act, it says, subject to under corroboration, subject to Section 31, where an accused is charged with an offense under this act, no corroboration is required. Now, that has actually caused some confusion with people who do not know what the existing legislation is. Back in, I think, 1994 or 1996, there was an amendment to the Evidence Act that abolished corroboration. So, as the law now stands, corroboration is not required in sexual offences cases. It's actually not required at all for any criminal offences. But what happened before is the judges still had to give a warning to the jury that although corroboration is not required, you can go on the evidence of one person, you can take it or leave it. We must warn you that where there's no corroboration, it's dangerous to convict the person. It's not required by law, but the law says we must warn you. No, that was a nonsense. If it is not required, it's not required. Corroboration has been done away with in most places in the Commonwealth. The requirement for the judge to make that warning has been done away in most recent sexual offences legislation. It is like Mike saying to you, Tish, you don't need to do this. But if you don't do it, I can have to warn everybody in CBC that you may be dangerous. It makes no sense. Either you need to do it or you do not need to do it. So all this amendment did was strip away the need for the judge to make that warning to the jury. Now, it doesn't prejudice the defendant in any way because his lawyer is free at any point in time to make that point himself. When the lawyer is wrapping up doing his submissions, he can say, you know what, the law says there's no need for corroboration. However, in these circumstances, the evidence does not match up. It does not reach a required standard of proof. This is dangerous to go on the complainant's evidence alone because the rest of it is so completely shaky. It's literally one person's word against the other and all the other evidence was shaky. The lawyer can address that. What it does is remove that obligation from the judge. The judicial officers were complaining that it was a nonsense. I can't say it is not required and then warn that, you know, although it's not required, it's unsafe to convict the person without it. So that's all that does. It does not, the lawyers are going to quarrel because it was an additional shield for defense counsel. But any good defense counsel can actually give that warning or make that point himself when discussing the evidence. It should not be for the judge to do it because it confuses things and then it actually confuses juries as well. So all we did was remove the requirement for the judge to warn. But corroboration is not currently required. It was not required before the amendment. It was not required since 1994. That's like 30, I can't remember, my math is shaky. So for about 30 years, it has not been required. So this does not prejudice anybody in any way.
All right, so basically what it says is, you know, it's up to you to try your case to the fullest extent.
Correct.
But you don't have to do certain things if you don't deem it fit.
Correct.
Full stop.
A good lawyer will protect his client and warn the jury of all the things and all his client's possible defenses. Is not for the judge to do it.
All right, Fabian.
Yeah, I hear the minister. And I kind of wonder why would you have to wait until the full development of the case to really deal with evidence, you know? And I mean, while sitting here, one of my colleagues also asked, so will this also be applied in the situation if a man is making the complaint in terms of it being taken with a degree of seriousness where you don't need evidence? A man could say, well, look, you know, this lady raped me, and would it be taken in the same light as if a woman said, he raped me?
I think we're looking at corroboration. Where the breakdown might be is whether is it moving forward with a case or a charge. Mm-hmm. So if there's a charge that a complainant is saying, I've been raped, there's no corroboration needed for that charge to move forward. Is that your thought process?
Yeah, well, in order for it to move forward, well, yes. But it just comes across as if maybe it could be the ignorance and us not really understanding how the whole legal system works. But if you're telling me that a lady is going to make a charge at me, and that charge is taken, you know, there's no evidence to really refute that or anything, but I have a chance later on, like, is a question mark in my mind, like, really and truly, I start at the back already, you know, especially if the information has to hit the public domain. You know, I'm known as the head of the men's organization. If it does come out that this was not true, I damage. I mean, like the image out there in the public, and we are very unforgiving people. So don't come and say, well, like, okay, we have evidence that this never happened, but then what? you have to wait until the case develops for that to then come out. I guess that's where the confusion comes in my mind.
The easiest explanation for this, because sexual offences, sexual relations are a very personal and touchy topic, so it gets clouded with emotion. So let's step away from sexual offences for a second. If I throw a rock and hit you, and you go to the police and say, Abrams threw a rock and hit me, and then you bring another one of your friends who was there, and he say, yeah, I saw Abrams, that's corroboration.
Right.
And then 2 friends, so the more people you have to back it up, or the more evidence you have, and you bring video footage and whatnot, so the more evidence you have, the stronger your case is against me. But that should not affect you. If I threw a rock and hit you and nobody was there to see, you should still be able to make your case. You present your evidence. Say Abrams was wearing a red shirt, a blue pants, right? He had a rock in his right hand, he had a bare bottle in his left hand, whatnot. And I will make my defense. And the jury will decide based on what is in front of it and how the persons present themselves, who it believes. It's the same thing for sexual offense. Right? If a lot of times the corroborating evidence is actually like DNA or medical evidence or something, or but if that is not there, should a victim be prejudiced in their case because it's only their say so? If they're convincing and the defendant is convincing, the jury will have to decide. But that's what the juries are there for. The juries are there to hear the evidence and decide who is telling the truth.
Is this along the lines of where we hear of someone going to court and then you hear they were not required to plead to a certain charge that is made against them, along those lines?
No.
Is that something totally different?
Entirely different.
Okay.
If a charge is indictable, is a charge that must be tried in the high court, then you can plead in the lower court. You turn it there for bail. But because the lower court cannot take your plea at that stage, it says you're not required to plead it.
Okay.
You will make your plea when you get up to the high court. So something completely different.
I think there's still a little gray area for the lay person, like us, who like Fabian said, who might be a little taken aback that based on solely on what someone says or what we might deem as hearsay, that you can move forward with a charge without any corroborating evidence.
But if you think in particular sexual offenses, they're generally not subject to witnesses. It would be a very foolish person who goes and tries to molest, assault, rape somebody in front of 10 people. So generally, the allegations of sexual offenses occur in situations where it's one person saying that we were in this space by ourselves and this other person did that. Right? What the law has said, you know what? I am not warning the jury that it's dangerous to take the word of one against the other, as opposed to one, and that one should have 3 or 4 other supporting witnesses or other evidence to support their case. What it simply said is the judge the corroboration was not a requirement. But although it's not a requirement, the judge still had to make the warning to the jury. What the law has now said is the judge does not have to make that warning. Let each party present their evidence, and the jury, who are people of common sense, they can look and evaluate and make that decision for themselves, and the lawyers can put the case. So I don't see there's any actual prejudice in it. I just want to be real clear. For the last 30 years, there was no requirement for corroboration. So we have not touched that. We've just removed the judge's obligation to warn the jury.
All right, there's someone else on the phone line. Welcome to the People's Business. Good evening.
Hi, good evening. I'm going to ask a question reference rape. Is the new legislation have a different definition for rape now?
I'm understanding you to be asking if the definition of rape has changed?
Yes, please.
So the definition of rape, I'll actually read it. It's probably easiest to just read it. Or I'm not saying it immediately, but rape is where, for the person in section, rape includes the introduction to any extent in circumstances where the introduction of the penis of a person into the vagina of another person would be rape. So the penis or any other part of a person's body into the anus or mouth of another person. So what it does is try to make the distinction between females, right? So it's now gender neutral. Anybody can rape anybody else. If you insert a body part into the mouth or vagina or anus of anybody, that is rape. Whether it's a man inserting the body part or a woman. So, I mean, sorry to get so graphic.
No, but
you
the thing about it is that the only thing a woman does a body part can insert into a man is what? Her breath in his mouth, but she doesn't have anything to insert.
No, but there's talk of objects or
right. So he didn't let me get to that part. If a woman finds a way to insert her fingers into you, right, that is rape. If you insert your fingers into a woman without her consent, that is rape. It doesn't have to be the penis. It can be the fingers. It can be an object. It can be a bottle. It could be a toothbrush.
So will that come under the offense of sexual molestation or sexual assault?
No. Understand? Hear what I'm saying. If you penetrate another person without their consent, with any object or body part, right, into their with respect to body part into their vagina, anus or mouth, with respect to an object into their anus or vagina, that is rape. It's not sexual molestation. For any time you insert something into somebody else without their consent, you cross the line. And why it makes a difference, right, is sexual assault attracts a much lesser penalty than rape. For rape, you can get up to life in prison. So don't try the technicality, but I didn't put in my penis, I used my finger. If you use your finger, it is rape as well now.
Okay, then.
Sorry to be so graphic, Chief, but I hope you understand.
Yeah, I think it's necessary.
I understand now.
Okay.
All right. I think it's necessary for us to have conversations at this level for people to understand precisely what we're talking about. And this might be one of the areas that we talked about, Fabian, where it's going to be very difficult to have these conversations without the stereotypes that we talked about or people shying away. Even as we talk, you know, some people feel shy and you're going to hear the giggles and so on that comes behind it. So you definitely have to think about how we will shape these educational campaigns, not only to educate young people or minors, but also the general population at large. All right, it's time for another break here on The People's Business. When we come back, we're going to try to delve into another area which was covered, which deals with the disabled. That's all next. Welcome back to the People's Business. We have a caller on the line. Let's take this call quickly before we go into the amendments to how we deal with mentally disabled people. Good evening to you. Welcome to the People's Business.
Hi, good evening to you and your guest.
Good evening. Welcome.
Thank you. I'd like to raise 2 questions, please. Well, I joined the program late, so I'm not sure if these issues have been touched on, but I recall years ago, a female nurse was charged for raping a student doctor. The case failed. It was pointed out that under the definition of rape in Barbados, as the minister stressed, penetration and so on, it was indicated that that would not constitute rape because the female did not insert anything into the male. So I just want to know if the legislation still is of such a definition that if a woman effectively forces herself on a male, that the law is saying that she cannot be charged for rape.
Yes, rape requires penetration. So if she forces herself on a male, that will go towards another sexual offense. But penetration is necessary for the offense of rape.
And your second question, sir? All right. I believe that caller has moved away from us. Quickly, as the time dwindles, let's talk about the amendments that will be made to cover those who might not have the mental capacity to be able to give consent.
So that section was actually really untidy because it held initially to the old definitions. It said if somebody did something with an idiot, imbecile, or subnormal person, that language now has to go. But effectively, if someone is suffering from a mental or physical disability to the extent that they cannot give consent and you engage in sexual acts with them, then yes, that is an offense. But you also need to be aware. So it can't be accidental. So you need to know that that person is disabled to the extent that they can't actually give the consent. So if it is a grown person who has the mentality of a 10-year-old child, and you know that, and you engage in sexual acts with that person, then it is an offense. If the person is in a coma or unresponsive or unable to communicate, and you have sex with that person, that is an offense. So yes, so for the vulnerable who are not able to actually give the consent, then you cannot engage those persons in sexual act. And you don't escape by saying that they're over the age and that they didn't object. Right? If you know that the person could not actually consent, their disability was such that they didn't understand the act, they didn't fully appreciate what they were doing, or they actually literally couldn't give consent, then you've committed an offense.
And Fabian, I saw you nodding in agreement.
Yeah. I think these amendments are extremely needed. The disabled community is one that is often not really a lot of attention paid to. And the fact that this really took into consideration how the act saw persons with disabilities in terms of the language as well, I think is extremely commendable. Yeah.
And just to cap off that point, if you do it with somebody who is disabled to the point where they can't actually give consent or they don't understand, you're liable to life imprisonment. So it's even if it doesn't constitute rape, right? You are still attracting a rape-like sentence.
I just want to ask one question. Is there any penalties for false allegations? Just a bit, like these things happen.
Perjury.
Okay.
So the answer is no, because that's on the books already. So no amendments there.
Nothing in here, but that's covered by the law, if it can be proved.
Okay.
All right. So regarding the role of generally protecting, particularly our minors, but in relation to the amendments, what message would you like to leave with our community about how they should move forward in finding out more about how they can move forward and what their general responsibilities are?
So this legislation very likely will never concern most of us. Most people who operate within normal concepts of what is normal in society, in a responsible society, will never have cause to collide with this legislation. For those who tread that fine line, I tell you, please become aware of the legislation. Children are off bounds. Anybody under 16 is out of bounds. Disabled persons who can't give consent, out of bounds, right? And I mean, we've discussed a lot of the others in great detail, but these amendments were made to protect the most vulnerable and to increase, in some respects, the level of the sentencing to show how seriously we're taking it. We're going all out to protect our children. We're going all out to protect our vulnerable. And we're balancing out that we're not distinguishing between male or female. The law applies equally to both sexes for certain offenses.
All right, I want to thank you both for coming in and sharing with us tonight, Fabian, Sargeant, for the areas that you advocate in. Thank you so much for your work, and for Minister, for you making the trek here to have this conversation with us. We've not touched on even the tip of the iceberg, really. There's so much more to explore. We know in terms of what you talked about, culturally, there's some picture of all of us as a child, completely naked somewhere. And these are things that we need to work through if we're going to be at ease with what's happening. So I'd encourage you to reach out and ask questions if you do have them. We want to thank you for joining us tonight on The People's Business. We definitely had an insightful discussion on the amended Sexual Offences Act, or the amendments that are coming, and their significance for the protection of our children here in Barbados. The responsibility to safeguard our youth falls on all of us. So again, thank you so much for joining us, and do have a good night.